attorney so that policy and changes could be made and that I could attend hearings in court to stop violations from occurring, such as terminating parents' rights when the tribes have not even been notified. Does that answer the question?
Yeah, thank you. Ms. Esch, what other responsibilities does your office have?
So Minnesota is #1 in the nation for the removal of American Indian children from their homes. The Minnesota Native population is just under 2%, but in child welfare, between 20 and 25%, American Indian children are removed from their homes. One of the things that I've been doing since 2018 is I go to the Shakopee Correctional Facility and I educate the moms of Native children there on what their rights are, so that the moms, even if they are incarcerated, they should be able to have visits with their children. So I've done that monthly since 2018. Then, of course, 5 years ago, we had to stop in 2020, and then we just started back up again. The other thing is I observe court hearings around the state now that they're in Zoom. Previously, prior to COVID, I would be at court hearings, and if I believed that there was a violation, I would stand up to let the judge know so that a parent's rights was not terminated on the spot. The other thing that I do is I work with the community, I work with parents, I work with grandparents to provide them with information resources. Currently, we are an agency of one, and that's just me.
And so clearly the provenance of this bill is you must do some court filings in connection with cases, I assume not as a party, maybe
No.
as a friend of the court? How does that work?
Not really as a friend of the court, but as a neutral, basically shining the spotlight. Judge, this is what the Indian Child Welfare Act says, and for this case, this has not happened. And so it's up to the court, for the court to make the court's own findings. What has been happening is I would send a letter to the court, and I would ask the court to waive the filing fees, and some judges have, but some judges have not. For some of the cases, even if they did not file my letter, they did refer in their court findings reference as to why the case could not proceed forward. So they actually cited information that I provided to the court. As an ombudsperson, we are a neutral. We provide information and resources.
And the courts are accepting filings from non-parties just as a neutral, interested organization, and they will do with it whatever they wish? Is that the idea?
Well, Minnesota has 87 counties, 89 different ways things get done, because St. Louis County has 3 courthouses. So there are some counties where the judges will waive the filing fee and accept my letter and file it. But there are also counties that will not do that. So then what I need to do is then I need to speak with the parent's attorney or speak with the guardian ad litem to see if they could go ahead and file my letter. Because our office cannot afford $285. When this agency was created in 2021, we were appropriated $190,000. And that included my salary and rent and paying for computers and everything like that. So we do not have extra monies to pay to the courts.
Sure, thank you. Just trying to get an understanding. I was not aware that your office was involved in providing information to courts in specific cases, and I'm glad to hear that you are. I just didn't know about it, so I appreciate that. Senator Pappas has a question.
Thank you, Madam Chair, and I think this is a really excellent idea, and I'd like to ask Senator Kunesh if I could be a co-author.
Oh, absolutely, thank you.
Thank you.
Senator Carlson.
Thank you, Mr. Chair. And I guess I have kind of a jurisdiction question for you. This is for federally recognized tribes. And is there any service that you provide to those who are not a member of the federally recognized tribes? Because I know it's hard to get federally recognized, but there still are indigenous people that could use ombudsman services. And I'm thinking of one that's in my district, the Mendota Metawakan community. And I'm wondering if you have any kind of either service that you can recommend for them or referral that you can recommend to them.
Ms. Esch.
So the Indian Child Welfare Act and the Minnesota Indian Family Preservation Act will only apply if a federally recognized tribe says that the child is eligible for membership or an enrolled member of the tribe. We are the Office of Ombudspersons for American Indian Families. We don't just work on cases that have federally recognition for the children. As someone tells me that this child is Native, then we can go ahead and work on it. I may not be able to pound my ICWA hammer or pound my MIFPA hammer, but then what we can do is we can look at it, and I've had cases where it started as a non-ICWA case. It went as an ICWA case because of the information that the grandparents were able to provide, and then they reached back up to the tribe. It's up to the tribes to determine as to who their citizens are. The reason for the federally recognized is the fact that the Indian Child Welfare Act only applies for federally recognized tribes.
Okay. Thank you, Mr. Chair.
Senator Howe.
Thank you, Mr. Chair. And I guess, and maybe I missed it, maybe I didn't connect all the dots, so maybe help me. When is it that the tribal nation couldn't file the action, but the ombudsperson does? I guess I'm trying to figure out what instances that the tribal nation couldn't file the action and exempt the fees where you have to file the action and the tribal nation cannot, that we'd have to exempt your fees and not, that they wouldn't be able to do that. I guess I'm just, if you can clarify that for me, I think I missed it.
Ms. Esch.
So in juvenile court, they have a thing called CHIPS, Child in Need of Protective Services. So the counties will file the petitions to remove the children from their home to say that something is necessary. If a case is in tribal court, our agency does not get involved. In county court, it's up to the tribes if they are going to intervene in the case to provide testimony to support the out-of-home placement because the parents need help or something like that. The ombudsperson will look at the case to determine, especially if they're moving to terminate a parent's rights, did the county do everything that they are supposed to do? And one of them is to provide notice to the tribes. If they did not provide notice to the tribes, they should not be able to terminate parental rights. Because once you terminate parental rights, you terminate every relative that is attached to that person. They're just gone forever. So my role is to ensure if they're going to be moving to terminate parental rights, that they need to dot their I's, cross their T's, and double check with that. And in my role, because I'm a licensed attorney, I have been able to stop that from happening so that the court will look at it and do what needs to be done, maybe requiring them to do what needs to happen or just outright deny the request to terminate. So that is what I do. The service is to the court, because ICWA is a unique area of the law, and I can provide the information. So generally, I send like about a three-page letter to the court, letting the court know as to what the rules are.
Senator Howe.
Thank you, Mr. Chair, and thanks for that answer. I think that clarifies it a little bit, but couldn't you notify the tribal nation that this action is being taken place, especially if they hadn't been notified, and then they could file?
But it's not up to me to notify the tribes. The petitioner needs to send the notice, the ICWA notice, and the petition, and the family genogram to the tribe by certified or registered mail return receipt requested. So that is a requirement.
Senator Cron.
Thank you, Mr. Chair. So I do a little bit of work in child protection, and I understand what you're talking about, but how, if a tribe doesn't get notice, and they should have, how does it come to your attention that it exists in the first place, that the case exists, and that the tribe didn't get notification?
Ms. Esch.
So it can come to me from various different ways. I observe court hearings around the state, especially now it's on Zoom. I can look at the case to see if the tribe was provided notice or if the county filed the required green cards prior to the admit deny hearing. The guardian ad litem can contact me. The parents could contact me. Foster parents could contact me, and definitely grandparents.
Senator Cron.
Thank you, Mr. Chair. And thanks for that answer. So you're kind of like the backstop, a resource to intervene in a case where the tribes didn't get notice and aren't following ICWA to the law. You're kind of a backstop where somebody can notify you or you otherwise find out about a case. You want to intervene in the court action, and simply that, some courts don't even make you file a motion to intervene and some courts do. And in those cases where they do, you just simply want the filing fee waived to intervene so you can send the court your letter. Am I getting that right?
Ms. Esch.
We don't intervene because we are an ombudsperson, and we just provide the information resources. And under our duties is to just ensure that the county is in compliance with the Indian Child Welfare Act. So it's up to it's providing information to the courts, and then you've had parent attorneys who have then filed motions to invalidate it.
Mr. Chair.
Senator Cron.
Thank you, Mr. Chair. So what is the, if you don't bring a motion to intervene, then what is the filing fee for?
Anytime you send a letter to the court, there is a required filing fee, the initial, I think it's $285 filing fee.
Mr. Chair.
Senator Cron.
Thank you, Mr. Chair. So you're not even filing a formal motion to intervene, you just want to get a letter into the court file, and some courts are requiring you to do a full-blown court filing fee to do that. And so this would just make it clear that you can file the letter without that. Is that right?
Yes.
Ms. Esch. So I just have one follow-up question. What level of access do you have to public court records on the internet?
So our agency has access through the MGA with it. We do not have access to the state SSIS, of which I wish that we had access to the state SSIS. We could do our work more efficiently, but we have access to MGA. And because in 2016, we have a administrative order for the Minnesota Supreme Court, where if it's regarding ICWA, I could also go ahead and look at it, even if it's filed with confidential status.
All right. What is SSIS?
It's the state child welfare system that DCYF has, and they've been talking about it as to that they need to get it upgraded and how many millions of dollars that it's going to cost for them to get it upgraded. But our agency does not have access to that
Why is that?
because they won't give it to us.
Well, I'd be interested in hearing maybe some reasons why and exploring what, if anything, we at the legislature can do to facilitate that access. I'm jealous of you that you have MGA access, which is not generally available to the public, but I can see why you're a government agency. You have that, so you would need that at least to be able to access the court records, to know what's in all the filings. All right. Any other questions or comments? Senator Limmer.
Mr. Chairman, just a side note. We often have discussion about uniformity of the judicial branch, and this might be a prime example of, after listening, hearing that some courts demand a filing fee and others don't for the very same classification of action. Just something to put in our memory when that issue comes up again. This is another example of lack of uniformity in our judicial branch.
And there is a value to institutional memory. Any further questions or comments from the committee? Senator Verbetten.
Thank you, Mr. Chair. Thanks for bringing the bill forward, Senator Kunesh. I had actually sent you an email asking to be a co-author as well, and I also wanted to thank you for the work that you're doing to educate our incarcerated parents in Shakopee. There's just so many. Very grateful for that.
Thank you very much.
Want to make the motion? Senator Verbetten.
Thank you. I make the motion that Senate File 472 be recommended to pass and be referred to the Senate floor.
Senator Verbetten moves that Senate File 472 be recommended to pass, be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Kunesh. Ms. Ash.
Thank you very much. Mahalo.
All right, next up, Senate File 1119, Senator Maye Quade, come on forward. And members, the anticipation is that there will be a motion at the end of the presentation to pass the bill and re-refer this to the Committee on Commerce. And I understand there's an amendment in the packets. Is this the first committee stop? No, that was withdrawn, so it came here first. All right, Senator Maye Quade, do you want to describe the bill to us first, and then we'll take your author's amendment?
Sure. You want me to do my whole presentation? Can you see my screen?
Go right ahead.
All
Yeah,
right.
you can see the screen.
All right. Mr. Chair, members, thank you so much for agreeing to hear Senate File 1119. My bill to require that the nudification functions on apps, platforms, and websites be turned off in Minnesota. That sentence is a little jargony, so I have some visuals to break it down. With the advancement of AI, many things are possible today that would have been unimaginable even 5 years ago. Some good and some bad. Some good, for example, if today you go into Facebook and ask it to make an AI-generated photo of you with different features, so me with purple hair, you might get this picture. Just for your enjoyment, I'll share that I didn't think that this picture looked very much like me. In fact, it was too young, so I asked Facebook to make a picture of me with purple hair, but I'm in my mid-30s. This is the picture that Facebook made. That's commentary on something, but I just wanted to share that with you. But if I ask Facebook to make a picture of me naked, it doesn't do that. It won't do that. To be clear, it can do that. It just isn't turned on in Facebook. This is the reality for many generative AI programs that we're familiar with. But there are some apps, platforms, and websites that will nudify a picture or a video of someone. That is, they will take a photo or a video of someone who is clothed and then make them naked, nudify them, show them without clothes on, or engaged in sexual acts. Or it can take an already existing pornographic image or video and then take a person's face from maybe their wedding photo or from a family photo for Christmas or the New Year, and it can create a new video or image now showing that person from their lovely family photo engaged in pornographic or explicit content. And because AI is both very advanced at this point, as well as trained on pictures and videos of real naked people, the nudified photos and videos are very, very real. And I want to give you some examples. So I think we all kind of think of AI photos looking like this, very realistic, but clearly not a real person. It's kind of like a drawing and a real picture put together. But AI now looks like this. This is an AI photo. There are tiny flaws in this photo that if you study it, you can tell that it's AI. But at first glance, this looks like a very real photo. And I zoomed in so I could show you what those are. So for example, this young woman has 1, 2, 3 legs. Or, and true to AI, they still haven't gotten fingers and hands quite right. I don't even know what appendage that is. But you have to really look at this photo for a long time to see that it is AI. You can't tell from casual viewing. So here's what that means for us. Any person can take a picture of any one of us from online, from the grocery store, walking down the street, and put it into an app and create a very real-looking photo of us naked. They could put that on social media. They could hang it up in their house. It means any person can take a picture of our children or grandchildren from online, the grocery store, or playing in a park, and put it into an app and create a very real-looking pornographic video of them naked. They could share it. They could put it up in their house. These apps are available on every cell phone for any person of any age, on every computer. They're all downloadable in the App Store, both Google and Apple. And it's creating problems, especially for kids. I put this article in your packets, but I don't know why kids would know that something they could easily download on their phone is illegal, because dissemination currently in Minnesota of non-consensual sexual deepfakes is illegal. But they can download these apps on their phones, and they're doing that. They're nudifying their teachers, their classmates, their siblings, friends. And so my bill simply requires that apps, platforms, and websites have the nudification function turned off. You can still make pictures of people with purple hair, no matter how old they are. But you can't make them naked. This legislature took great strides to prohibit the dissemination of non-consensual sexual deepfakes in 2023. But we based that law off of a different law, and it was colloquially called the revenge porn law, the dissemination of real naked photos or videos that someone might have sent you that you send to others without their consent. And while basing new laws on old laws is a good framework to usually work with, there was one large mistake. For the revenge porn, the crime is the dissemination. But really here, for this AI-generated nude videos and images, the harm begins at creation. And because these are as easy to access as ChatGPT, we know that kids are doing this to their teachers, to their friends, but loved ones are doing it to people that they're closest to, and you'll hear that from one of my testifiers. These functions should be turned off everywhere, in every state, in every part of this globe, to be honest with you. But we are here in Minnesota, and we can do what we can do in Minnesota, and so I just ask that we have them turned off here in our state. And with that, Mr. Chair, I would be open to amendments. I have testifiers. We can move forward however it works for you.
Well, so let's at least start by putting the bill in the shape that you'd like to leave this adopted. So move that and moves adoption of the 83 office amendment. All those in favor say aye. Aye. Opposed? Bills, the amendment is adopted. Would you like to move forward with your testifiers at this point, then?
Yes, Mr. Chair.
All right. We have Sandy Johnson testifying remotely.
Do I need to take my computer off for that to work?
Pardon me, Senator Maye Quade?
Do I need to take my computer off for them to be?
Well, we'll find out here.
Sounds good.
Oh, we have control over the screens.
Thank you, Mr. Chair. Would you like me to proceed?
All right. There you are. You just showed up on the screen, Ms. Johnson. Go ahead. Please identify yourself and your affiliation for our record, and go ahead with your testimony.
My name is Sandy Johnson, and I'm the Senior Legislative Policy Counsel for RAIN, which is the largest national anti-sexual violence organization. Thank you for taking the time to consider this bill, which will protect victims from image-based sexual abuse. Imagine a teenager, a mother, or a businesswoman. One day, this person receives a message with a photo they never took, which shows them naked. Imagine that person looking at this photo that is so realistic that even they can't tell it's fake. In that moment, their life will forever be changed because that victim knows this photo was created without their consent. They have no control over who else will see that photo, and their entire world is now unsafe. This bill takes the necessary steps to prevent the creation of non-consensual sexual images which harms victims. These nudify websites allow any user who knows how to upload a photo to victimize anyone. These websites offer premium features for different sex poses of the victim. They advertise on mainstream social media platforms with slogans such as, quote, "undress any girl you want," end quote. Once the images are created, they can be posted anonymously, are rapidly and widely disseminated, and become nearly impossible to remove. These websites use a product design that profits from harming victims. Overwhelmingly, people in these photos do not consent to their image being manipulated. In fact, 96% of manipulated images were non-consensual, sexually explicit, and featured women. Victims of this image manipulation report significant feelings of helplessness, hopelessness, trauma, anxiety, and depression. More than half of victims do not know the identity of their perpetrator, increasing the harm. Perpetrators further harm victims through extortion, leading to financial losses, withdrawal from family and community, and even death by suicide. When methamphetamine was ravaging communities, Minnesota targeted the chemicals used to create the drug. It is time to target the websites that create non-consensual intimate images. This bill will hold websites accountable for their product design, and we urge you to pass this bill. Thank you.
Thank you, Ms. Rain. I'm sorry, Ms. Johnson, on behalf of Rain. I don't know if you're planning to stick around. Any members want to ask questions of Ms. Johnson at this time? Or if you're able to wait around, Ms. Johnson, if there are questions as the discussion proceeds, you'll be available for that, I hope. We also have a Megan Hurley to testify. Ms. Hurley, go ahead and identify yourself for the record and your affiliation, please.
Hi, I'm Megan Hurley. I've been a lifelong resident of Minnesota, and I'm here today to share my experience as the victim of deepfake and face swap technology. I learned this past summer in June of 2024 that a man I had known for 20 years and at one point considered a dear friend of mine had used a picture I posted to my private Facebook page and an easily accessible website to make hyper-realistic nude images and pornographic videos of myself and around 80 other women who also mostly call Minnesota their home. This has created irreversible harm to me and these other women, and I cannot overstate the damage this technology has done. It broke me open to be violated this way. I missed 2 months of work, depleted my savings, and went into debt to try and recover, as well as identify and notify the other women who had been victimized. My workplace has made great efforts at cost to them to make me feel safe at work. I'm a massage therapist, unfortunately a profession that's already sexualized. I've been humiliated. I have never taken nude pictures of myself. However, because of this easily accessible website, there are convincing graphic nude images and videos online of me for forever. It is too easy for one person to use their phone or computer to create convincing, hyper-realistic, non-consensual nudes of you, your friends, your families, your children, and your grandchildren. I don't understand why this technology exists, and I'm appalled there are companies out there making money in this manner. I support this legislation to be strengthened to hold these companies responsible and prevent harm to other Minnesotans. Thank you.
Thank you, Ms. Hurley, and I'm sorry for your experience.
Thank you.
Any members of the committee have any questions for Ms. Hurley at this time? Senator Kroon.
Thank you, Mr. Chair, and thank you for your testimony. Just obviously support the intent of the bill. I'm just trying to walk through it and make sure I understand all of the terms and implications. The first thing that.
Sorry to interrupt, Senator Kroon. Is this a question for Ms. Hurley?
Oh, no, I'm sorry. Sorry,
Okay,
Mr.
then
Chair.
Ms. Hurley, you're welcome to return to us
Sorry
in the
about that.
gallery if you wish.
Thank you.
We'll let Senator Maye Quade answer the technical questions about the bill. Senator Kroon.
Sorry, thank you, Mr. Chair. Just walking through the bill, the part that stuck out, or one of the things, was the civil penalty of $500,000 in the, under Section 831 for the AG action, and how that meshes with the civil action and the mental anguish and suffering damages, which under the civil action of that would actually go to the victim, whereas the AG action, it would go to the AG as a civil penalty. I guess my general thought is just what you're, is obviously we want to prohibit this and probably need some hefty consequences to do that, but does having such a high civil penalty, is that almost counterproductive from, or wouldn't you rather kind of maybe beef up the civil penalties so that it would go, they would still be responsible in a significant way, but it would go to the victim? I'm just, what your general thoughts are on that?
Senator Maye Quade.
Thank you, Mr. Chair. And I want to thank nonpartisan staff, in particular, Ken and Priya, for helping me with this bill and really thinking through a lot of these hypothetical questions about so many more things. I am totally open to how we want to structure the consequences in the way that is the most deterrent for companies to allow this to happen or to do this work to nudify Minnesotans. I think the goal, is to partner individual action with state action, because it is both an individual harm and it harms our society, it harms our state. And so I'm totally open. If you have suggestions for structuring it differently, I'm very open to that.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Maybe this could be, I don't know, maybe there's a way to funnel the civil penalty funds back into a pool or something that would go to the victims. I don't know. That could be one thought. And then my other question is, and this may be for council, I don't know. I'm just looking at the term in line 1.20 with the civil action, which is mental anguish or suffering. And if that term is used in our statutes already, and or are we making up a new term? Just kind of curious about that.
Mr. Chair and members, the phrase mental anguish and suffering is used in the Human Rights Act. The specific phrase mental anguish is used in both the civil action for the revenge porn statute as well as the civil action for non-consensual dissemination of sexual images, sexual deepfakes.
Senator Kroon.
Thank you, Mr. Chair. Not sure who to ask this, but how does that, and that's good, if it's already in statute, that's good that we're not making up a new term, but how does that differ from like the tort, intentional infliction of emotional distress? Is there like a different standard, or has there been any case law interpreting this, or, and maybe there hasn't been, I'm just curious, maybe to council.
Ms. Primo.
Mr. Chair and members, I have not looked into that issue, and I'm happy to do that now or after committee. This would not eliminate a potential common law common law action. I'm not sure if that is maybe what you're somewhat getting at. So that could be brought with this.
Senator Kroon.
Thank you, Mr. Chair. So yeah, I'm just thinking through what a civil lawsuit would look like in a situation like this, and you could have multiple counts, and one could be the common law tort of intentional infliction of emotional distress. Another count could be the statutory provision for mental anguish and suffering. What I'm thinking about is in that lawsuit, you got two similar terms. Could be very confusing to the jury, maybe. I don't know.
Ms. Primo.
Mr. Chair and members, and just another thing to point out here. This bill permits a civil action against the, I guess, entity that allows this technology to exist. I'm just thinking through the elements of an intentional infliction of emotional distress. That could be challenging for someone to prove, to bring against that entity that permits this technology to exist, because it's not about the person who created it, that single user.
Senator Kroon.
Thank you, Mr. Chair. So what so maybe the tort would be for maybe the user that's disseminating, or if they disseminate it, and this civil action based on the statute would be for the website or the app owner. Is that right?
Ms. Primo.
Mr. Chair and members, yes, that's correct.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. But it could still be in the same lawsuit, presumably with different defendants. And you're still looking at slightly different terms, and maybe that's okay. I'm not saying it's bad. It's just something that came to mind about a single lawsuit, maybe multiple defendants, one with intentional infliction of emotional distress and one alleging mental anguish and suffering. Maybe that's okay. And I don't have if mental anguish and suffering is already used in statute, then I guess I don't have a problem with it. If we were coming up with a brand new term, I would maybe search for something that's already in statute, but sounds like there isn't an issue there. So, so I'll move on, if that's all right, to the next issue, unless anybody has any thoughts on that.
Well, first I want to say to members, the entire bill is within this committee's jurisdiction. It goes from here to Commerce if it passes. There are civil liability provisions in here, which we always see, but the whole bill is within our jurisdiction, so feel free to work on it as you wish. Senator Kroon, Senator Seeberger has a comment or question. Can I go to her first and back to you? Senator Seeberger.
Thank you, Mr. Chair. And Senator Kroon, the way I read this would be sort of an element of damage is similar to a personal injury lawsuit, where one of the items on the special verdict form is pain and suffering. So maybe they don't have like physical pain from a physical injury, but they might have mental anguish and suffering, and maybe that's the element of damage and the damages on the special verdict form that we would see. And how this differs from intentional infliction of emotional distress, as I understand it, there has to be a physical symptom that manifests from the emotional distress, so something measurable that you can go to the doctor for. And I don't see that as being included in mental anguish and suffering, the same as pain and suffering in a personal injury lawsuit. That's how I've kind of made sense of it.
Senator Kroon, before you go on as well, Ms. Primo wanted to explain a little bit about the content and maybe some gaps in the language of the bill, and they won't be fully informed for our conversation here. Ms. Primo.
Yeah, Mr. Chair and members, so just a couple things to point out. One piece is that this prohibition applies to consensual images and videos as well, including with adults who consent. And another issue, which I think has been somewhat highlighted in this discussion, is that this action does not apply to the user who creates the nudified image. And except for the case of child pornography, there is no other current law that makes the user liable solely for the creation of a nudified image.
Ms. Primo, I'm a little bit unclear on the first part. The prohibition applies to consensual images, including adults who consent. How would that work?
Mr. Chair and members, maybe a clearer way to say that is that there is no requirement of consent. The bill is silent. So if you had a situation where someone, for some reason, there's an adult consents to have a nudified image created of themselves, that would still be subject to the penalties and the civil action in this statute, in this bill.
All right, thank you.
Mr. Chair.
Senator Maye Quade.
Thank you, Mr. Chair. I just want to note for the committee, that's intentional, because the point is that this technology isn't available to anybody to nudify anybody. Because if I could nudify myself, then I could nudify anybody on this committee. And so the purpose is to have this function. It doesn't ban any specific apps or platforms or websites, because this is a function of those. You know, you could still do purple hair and just not nudify. And what I don't want is for people to be nudify at all, because how do you get consent for that?
Senator Kroon.
Thank you, Mr. Chair. Circling back, and then I'll work forward. I think maybe I'm fine with the different word with mental anguish or suffering. I know that it's for a different purpose, different standards, so just because they sound similar, that doesn't necessarily mean the jury is going to be confused with proper jury instructions, et cetera. So my main concern was to make sure we weren't making up a new term, or if there was another term that could be better used. But since it's already in statute, I think that's probably fine. As far as the consent piece, I see what you're saying. You just want it turned off so that nobody can use it even for consensual purposes. And maybe there isn't a technical way to do that. I don't know. I'm just wondering. I don't even know if there would. I'm just wondering if there's any First Amendment implications with that. I don't know.
Senator Maye Quade.
Thank you, Mr. Chair. I'm really glad you brought that up, Senator Kroon, because this is getting at specific conduct, not speech. And it's why it's really narrowly tailored. I think, you know, when I was talking with nonpartisan staff about, you know, one of the things that we thought of is that there's lots of different kinds of conduct that you might not want someone to depict you engaging in via AI, but that could be so broad, right? There's lots of things that you could depict me doing that I wouldn't want you to depict me doing it, but then if it was you, it wouldn't be that offensive, right? And that could apply for lots of different kinds of people for lots of different kinds of things. But honing in on the uniqueness of sex and nudity, and the immense harm that is shared by every single person, to be nudified and then have that potentially, I mean, I think about all sorts of people in the public eye, us included. I'm aware that every time I do a bill like this, it's very likely that somebody does this to me. That is a shared harm to everybody, and that's why it's really, really narrowly tailored to this one specific kind of conduct, and nothing else. Because once you get outside of that, I don't think we're being narrowly tailored for a compelling government reason. I think this is that, and we already have it, as Ms. Primo mentioned, in the child exploitation imagery. That statute is very old, and it already covers this. It is already a crime to possess child pornography that was generated by a computer. This would just stop people from being able to make it, or I guess stop the companies from allowing people to make it in Minnesota.
Does anyone else wish to ask any questions or make comments right now? Is there anyone else in the room that wants to testify? Senator Limmer, before I ask that. Senator Limmer.
Thank you, Mr. Chair. Senator Maye Quade, I see the word use is mentioned in the bill. If I can direct your attention to lines 116 and 2.7. I don't know if that needs a definition or not. Maybe council could weigh in on that, but seems like an awfully broad term, and I was wondering if that needs to be tightened in any way.
Ms. Primo.
Mr. Chair and members, if the committee believes that use is an ambiguous term and it should be further defined, that's a policy choice for the committee.
Mr. Chair.
Senator Limmer.
The reason I brought it up is you could have an individual who's actually producing this type for whether their own gratification or whether it's for distribution as an adult. What if it's a 14-year-old kid use the website to notify an image? Would that individual also be guilty of this law? And if so, what would be the penalties for such? Is that child going to receive a fee or a penalty up to $500,000? I'm just wondering, a lot of kids are little voyageurs on the websites, and I'm just wondering, how do they fit into this?
Senator Maye Quade.
Thank you, Mr. Chair. Senator Limmer, so the owner or controller of a website, which would require, generative AI algorithmic function in order to take a person who is clothed and make them naked, or take a video of a person who's clothed or superimpose or whatever. So it would require them to have that capability. If a 14-year-old used a app, platform, or website to notify somebody and had that, they would not be guilty. So the crime, or I guess the consequence here in this bill, is to the entity, the company that maintains these apps, platforms, websites. If a 14-year-old notified somebody through an app, platform, or website, the only crime that they would be guilty of is if they notified another child and were in possession then of child sexual abuse imagery. Even though they're a child, I think the crime applies to everybody. So if they did that of another child, it would be a crime, and it's a separate crime. I think it's 6.17.247.
Is there anyone, I'm sorry, Senator
Mr.
Limmer.
Chair, so this is targeted after the producers of these types of programs. I'm just thinking about the progression of technology. In a few short years, I would imagine, pardon me, the producers it may not be such a high technical challenge to create images like this. And we've seen that progression, that evolution of technology, where only commercial producers could create anything of a technical nature, and now everyone's making videos and things on their own home computer. This will probably go that route too. And so I'm just thinking a little ahead of time of how we can head that off in the future, if at all.
Is there anyone else in the room here that wishes to testify in connection with this bill? Just to make sure we have any testimony on the record before we continue our discussion here. Not seeing anyone come forward. Senator Howe.
Thank you, Mr. Chair, and I'm hoping someone can answer this question for me, but I guess, and this is, Senator Maye Quade, this is based upon taking an image of someone and altering it. And I have to believe there's some way to prove that this was a photograph or an image of someone and not an AI-generated image of no one. There's got to be a way to link this back to an original image, photograph. It can't be just an AI-generated person of, and I guess you'd have to prove that that started out to be someone before it was altered.
Senator Maye Quade.
Thank you, Mr. Chair. Senator Howe, I think I understand your question, and I'm going to answer what I think I'm hearing, and then you tell me if I'm hitting on it. Are you essentially asking, like, if somebody comes across an AI-generated nude image or video, but don't know who the person is. They don't know if it's a real person that has been nudified or just an AI-generated person that's been, okay. So I think in this case, so I'm thinking of my testifier and the experience of those 80 women. In this case, they know that that's themselves and then not them doing the action. But there's nothing in this bill that would require somebody who comes across something to like report it, right? To say like, I don't know if this person's real or not, but I came across potentially some AI sexual imagery. So this is really more of a tool for victim survivors and also our state if we are finding that, you know, there's deep swap AI is how some of these folks were victimized, and so that would be a target. And so if we're finding that a lot of kids in school, for example, right, I showed you the New York Times article, if a lot of the kids in school, you know, you're seeing that they're using one app, then the Attorney General can also take action to say, look, they're still allowing this to happen in our state. So it'd be more like, I mean, truthfully, it'd be more victim survivors who see themselves and say like, hey, that's not me, I didn't do that, and then working backwards from there.
Senator Howe.
Thank you, Mr. Chair, and thank you, Senator Maye Quade. So I guess that partially answers my question, but I may believe that that's me, but there's got to be a way to prove that that started out to be me, doesn't it? I mean, I can't just all of a sudden say, call up the AG and say, I know that that's me, I know that they notified me, and that's all the proof we need. There's got to be a way to prove that that started out to be an image of me, is where I'm going. I mean, how do you make that connection? And what's the technology to know, to be able to trace that back, that started out to be an image of that person? You know, otherwise I can turn around and say, I know that's me. It's got to be me. I think that's me. I believe that's me. Rather than how do I take that and actually draw that line of evidence back and say, this is how I prove that was that image of that person.
Senator Maye Quade.
Thank you, Mr. Chair. I definitely get your question, and we actually we grappled with this a little bit in some of our conversations with nonpartisan staff. So I'm going to turn you to the amendment, and I'm going to have you look at 1.8 and 1.9. We're essentially saying that the identifiable individual, so if you're looking at something and you're saying, well, that's my face, right? So we're looking at it and we can say that's Senator Howe. That would be the identifiable part. You don't have to say, here's where they took it from. Here's where they, you know, your picture's probably all over the internet. And so you don't have to say, here's where that photo came from. Seeing the video and identifying whatever's happening in that video or in that picture as Senator Howe, that is that's the point at which we know the thing occurred, is that you can see it and you can identify who that person is. They're an identifiable person, like we say on 1.9. Does that make sense? Does that answer your question? Kind of?
Senator Howe.
Thank you, Mr. Chair. Thank you, Senator Maye Quade. I guess I'm just trying to say that I can believe that that's me, but there are times when some people say that was me on that, and I'm going, I don't really see it, you know. So I think there's a struggle to make that connection sometimes, and that's the loose part of this thing that I'm not real comfortable with, is being able to draw that and say, but maybe the technology's there, and I'm not technologically savvy enough to be able to go there. I mean, so that's my only concern. That's where I'll leave it.
Senator Maye Quade, it looks like on line 1.7 of the amendment, you also have to identify the original unaltered image or video so you can compare it to what was or was not depicted there. Correct? Is that right? As an element of the case that's being made?
I get what you're saying. I'm going to have an open conversation with counsel here, if that's okay, because we also grappled with this because part of what is happening is something's being created, right? It's not, like, it says reveal, but it's not revealing anything. It's creating a new picture, guessing of what it would look like underneath clothes or adding a body or what have you. And so, I guess I'm just trying to, we spent some time, and that's what you see in the amendment before you, trying to figure out how do we put language in that is essentially saying that they're taking a photo or likeness or photos and likeness of you, and it's creating a video or image where you are naked or engaging in sexual acts, that it could be multiple photos, right? The AI picture I showed you from Facebook, that was 3 different photos that it took of me from different angles to make that, and it didn't really look like me. But that's what's difficult about this, is that it's creating something new, and it's an amalgam of both the identifiable person and amalgams of a bunch of other people in the world, and that's what it's trained on, to guess. So, Ms. Primo, I'm actually going to look at you and say, I get what the question is, and now I'm wondering, do we have to change the unaltered image or video so that proof that there was an original where you're clothed or not having sex is part of proof?
Ms. Primo.
Mr. Chair and members, I can see how the definition does place I think a burden on the plaintiff who files an action under this to demonstrate that at the very least, the part of the newly altered image or video that contains the identifiable piece, presumably the face of the victim or the depicted individual, they may have a burden here to show the court that this is where the original picture of my face came from, and it does not include all these other elements that are now in the now in the nudified image or video. I would imagine the court would need that sort of evidence and proof in order to make a finding that the entity violated this law.
To that point, Senator Kroon.
Thank you, Mr. Chair. I was going to say basically the same thing in line 1.18, the injured by provision in a civil lawsuit presumably would require the plaintiff to provide evidence, however they may choose to do that, through technology or, other means. They would have the burden of proof in that lawsuit to show that the original picture was of them. Otherwise, I don't know how they would prove injury in the lawsuit. I'm a little less clear, though, on the Attorney General provision in subdivision 4, how it would work there. It seems, and I'm sure there's a way, it seems pretty obvious to me in a civil lawsuit. Maybe a little less obvious in the AG part.
Senator Kroon, just so the record's clear, you're looking at the original bill, and that language is replaced by the A3 amendment. Remove the injured by portion. I don't think it changes your analysis, but it's just so we know we're referring to the same.
Thank you, Mr. Chair. Mr. Chair?
Senator Kroon.
Thank you, Mr. Chair. So did that remove entirely the injury provision from the civil lawsuit? And is that necessary to be, is it necessary to have that provision in there? Or is it enough to just say that the depiction in and of itself constitutes the violation?
Ms. Primo.
Mr. Chair and members, the injury provision was removed so that it was clear that violating subdivision 2 on its own and meeting those elements and the definition is enough to trigger the ability to bring this civil action. I imagine at least for some of the damages, though, then you would have to prove some sort of injury for those damages.
Senator Clark. Senator Kroon, you're on my list. Again, don't know if you already covered what you wanted to.
Thank you, Mr. Chair, and that might be okay. I'm not saying there's anything wrong with it, I'm just thinking through it. Because some, the actual or the compensatory damages part, obviously, you're gonna have to prove, and the mental anguish, the damages are personalized, so I think that element is still there without the word actually being in there, so that's probably fine. I guess I'm still kind of stuck a little bit on whether or not there's First Amendment implications here. I don't know if that's completely clear to me that there's not. I mean, as I'm looking out there at some similar issues, things that I would never even really consider to be speech, the court deems to be speech, whether we think of it as conduct or something else. And so envisioning a scenario where somebody does this in a totally consensual way, claiming speech, whether this would trigger First Amendment implications, I'm not sure. And I don't know the technology well enough to know whether you could, is it just, maybe my question is this, because maybe you know the technology, as I certainly don't. Is it, in your presentation, you kind of talked about it, turning the switch off. Is it in fact that easy? I mean, is there a nudification switch that these companies can just turn off, or is it more complicated than that?
Senator Maye Quade.
Thank you, Mr. Chair, and Senator Kroon. There's a reason why we're not specific into the manner in which they turn it off, because I'm sure it's different for each app, platform, and website. And so, for some of them, it might be rewriting code. For some, it might be just be taking features off of what their app allows. Sometimes searches, there's, and I think one of my testifiers testified to this too, that, you can go on these apps and it'll show you like the top 10 like sexual positions you can put someone in, right? You wouldn't do that. And so it's not, I guess, not on our side. It is about as simple as turning it off, removing that ability from happening. On the back end, it might differ from whether it's a website or an app and a platform or all three, what have you.
Senator Kroon.
Thank you, Mr. Chair. Yeah, and I certainly don't. Have you had any discussions with any, I don't know if there's any, I don't know who allows this to happen. I have no idea who these people are, but has anybody come forward? Have you any discussions of, or maybe even with the Facebooks and stuff of the world that currently don't allow this, about, I guess where my mind goes is they may be doing best efforts to keep people from using their product in this way, but maybe somebody's one step ahead of them or something. Is there anything in here that would protect a company that, I mean, these are $500,000 civil fine per instance, that's pretty hefty. Is there anything that would protect them if they are using best efforts to prevent this from happening, but, something happens?
Senator Maye Quade.
Thank you, Mr. Chair. I did have a meeting with TechNet ahead of this because I think almost all of the members, if not all of the members of TechNet that do this type of generative AI do not have this function. If they have generative AI, they do not do this function. And so there was no, pushback on the bill as a whole, and in particular that part. In fact, I think they would enjoy the opportunity to be seen as the good guys at some point in this calendar year. So the way that the technology works, I want to be really clear, is that because generative AI, it takes prompts and uses what it's been trained on from the internet, from scraping our photos and our writings and all of those things to generate like their best guess of what is. And so there's not really a way around on Facebook, you cannot generate a nude image. You just can't. You could probably generate something close, like a really skimpy bikini. I didn't try that one. But it will not show you essentially the parts that we've defined here in intimate part. That is not difficult to write into code. At no point can you, show, I'm not gonna name all the things or graphic, but show all of those things and define intimate part. So I feel like I might have lost the end of your question there, but it is possible to do. Most of the AI stuff that we use now doesn't allow it to happen. There really isn't a way around it because all of the things that it would have to generate and guess with are things that they can either make not available or make available. Like it's an explicit choice to say, here are the 10 best sexual positions you can put your classmate in with a picture. And it should be an easy choice to not offer that.
So we're good at generating hypotheticals here,
Yes.
but to spin this a little bit, I could imagine some nefarious actor trying to insert malware into an existing app, some feature somewhere that would enable this. Then the question is, what's the responsibility of the application owner to discover that malware, close loopholes that would allow that to get in, those kind of things, take it off as soon as reasonably possible. I suppose those could be defenses in any lawsuit, and common law would apply to however it would. I can also imagine a scenario when we get into speech issues, if by consent an adult decided to nudify herself, take a fully clothed image of her, have a nudified body, however she wants it to be, with this technology, and post it with a political message of some sort. That certainly would be considered political speech. Whether it's the government that's prohibiting it by passing this, because the First Amendment only applies to government action, would be another question as well. So I can, someone out there will be creative and will press the boundaries on this, no doubt, but we can, I think, only do the best we can to draft the statute as we think is most helpful.
Mr. Chair?
And the only other thing, well, Ms. Hurley, you wanted to add something on this point, and then I've got a sort of a technical.
Well, particularly in the website that was used in my case, in the user agreement that this man probably didn't read but signed in order to use this website and pay for it, there was language saying you're not allowed to nudify people. And a couple lines under that, it also said you are absolutely not allowed to incorporate children or animals in sexualized scenarios. And he was able to do it anyway on this site. So I would assume some of these sites do have language saying you can't do this, but it's happening anyways. And there aren't things in place in utilizing this deepswap.ai that prevented him from putting my body on a nude, putting my face on a nude body.
My impression is that the purpose of this bill is regardless of any notifications or user agreements,
Right, because
then will
most
become
of
the
us,
responsibility of the app to set it up so it can't be done,
yeah.
regardless of someone's attempt to do it. Is that correct, Senator Maye Quade?
Yes, Mr. Chair, it is.
So I've got a technical question. Senator, you had raised the issue on the A3 Amendment, line 1.6, whether the term reveal is the best term there, because it at least suggests that there is something that was covered or that was seen before that got covered and is now revealed. The term depict is used later in that same line. I wonder if the term depict instead of reveal would accomplish your goals, but in a better way. I'm raising the question. I'm trying to think out loud here as we are working through this.
Yes, Mr. Chair. In fact, I'm going to look at Ms. Primo again because I think we had said exactly that. And then we're like, does depict to reveal, or to depict an intimate part not depicted? I think that was what tripped us up. It does get tricky. Generate also might work, to generate an intimate part.
Generate an image of?
And it could be generate an intimate part not depicted by the identifiable individual. Because part of what this technology does is it can take one photograph, but it works better if you put in multiple because you need different, sides of their faces and different, all those kinds of things. And so I guess by putting in original unaltered image or video would imply that there's always just one. And maybe it's better to just say to generate an intimate part of an identifiable individual. But I am not an attorney. I just play one on TV sometimes.
But are you up to date on your CLE credits? That's the real question.
After today, maybe.
I think we're all going to get credit for that. While council is contemplating the language here, any other questions or comments from members of the committee? Senator Clark.
Thank you for bringing this forward. As a parent of teenagers who don't have fully formed brains yet, I think we've seen, I have heard stories of that run around the high school and run around the middle school, that this will help prevent trauma. So as we wordsmith and figure out how to make this well done, I think we, parents and those who are grandparents, probably have heard whisperings of the stories, and it's more than whisperings. It's reality for our testifiers, and fortunately not my kids, but my kids' friends. And so if we can figure out a way to get this done, it's going to prevent harm that is real. So thank you for bringing this forward.
Mr. Chair.
Senator Maye Quade.
I do want to point folks to the New York Times article that was put in your packets. The very last two sentences is a superintendent who had a spate of this happen in his school. And he said, schools and lawmakers need to act quickly because the abuse of AI is making students feel unsafe. You hear about physical safety, but you're not hearing about this invasions of students' personal and emotional safety. And when I think about the Attorney General's involvement here, I think I more often can think of a situation like this where you're having a number of superintendents and principals coming and saying, look, this is the app the kids are using, that they're able to access this thing. Because this isn't about punishing individuals. Of course, if individuals have the ability to do this, they're going to do it. What we want is to not have it be available. And so that would give the Attorney General the ability to say, look, insert your random app here. All these kids are downloading this app and accessing it. Stop, or here's the penalty and here's the fine. To your point earlier, Mr. Chair, about political speech, if a person wants to post themselves naked online with a political point, there's nothing that prohibits them from doing that. I think the concept here is that if I can nudify myself, then I can nudify someone else. And honestly, I am capable of taking a naked picture of myself and holding up political speech. And so I want us to, this technology shouldn't exist. It is really, really bad and detrimental to society. There are lots of ways to imagine people naked, see people naked, draw people naked, look at yourself naked, take pictures of yourself naked, but just existing in this world right now the way it is means that anybody could make a very, very, very real picture or video of us naked or doing sexual things. And that's so dangerous. And that is, to your point, Senator Clark, that's the purpose of this bill. And I appreciate the thoughtful wordsmithing because I want it to work in law. And it probably is going to take a lot of smart brains. And Senator Seberg, I appreciate your differentiation on mental anguish, suffering, and emotional distress. And Senator Kroon, I would like to bring in another, the Commerce Committee, to have the civil penalties go towards victim survivors, and I would love to work with you on that. So I'm really appreciative of the time of this committee because this is it's happening in all your kids' schools. And just because it's kind of happening out of our view, this is new to us, but it's not to kids, and it's just, we can get a little bit ahead of the game.
Mr. Turner. I know there was a side conversation here about where, under current law, a civil penalty that's obtained by the Attorney General's action ends up. Where does that money go?
Mr. Chairman, I can't say definitively, but we looked it up here, and in certain cases, it defaults to the general fund.
So it could be specified to go any number of places. If we chose to do so, I would assume. But if we say nothing, it probably ends up in the general fund?
That would be, Mr. Chairman, that would be my best guess for now. I will look into it.
Thank you. Still working on language, Senator Maye Quade. Senator Verbet, while we're working on language over here.
Thank you, Mr. Chair. Thank you so much for bringing forward the bill, Senator Maye Quade. I am authoring the bill for crime victim services funding, which is in deep need. So always looking for creative ways. And, you know, I think we should have robust conversation about it, but just want to put that out there as a bucket of funding where we've lost a lot from the federal government. We're sort of in a tough situation this year. We just heard from a number of organizations last week, like how dire the situation is. And I think, you know, those are folks who are survivors. So hope you'll take that into consideration.
100%.
Senator Carlson.
Thank you, Mr. Chair. And throughout our discussion here, I'm wondering, when does, because they're kind of parallel, when does the nudification become the creation of porn and become the distribution of porn, which is a crime? Is there a point here where you cross that line?
Senator Maye Quade.
Thank you, Mr. Chair. Senator Carlson, I'm so glad you asked that question because it gives me the opportunity to say that the crime of dissemination of deepfake sexual imagery begins when a company transmits these images and videos back to the user. So every company that has allowed deepfake pornography and sexual images in the state of Minnesota that has sent them to somebody here in the state has committed a crime under our statute. Now, that has not been prosecuted yet, and ideally, we would like to just make it so it's not available, but the dissemination begins when it's generated, because when you send it back to somebody's inbox, to their computer, whatever, their phone, that's the point of the crime, the first crime. With the creation of it, that is also, I mean, I don't think we have very famously, we don't have a definition for pornography, right? We know it when we see it. And then any further dissemination from further dissemination to other people would also be a crime. So the company commits the first crime, always. If there is deepfake pornography or sexual imagery in the state of Minnesota, the company committed a crime already under current law. And then if somebody sends that out, they are also guilty of a crime. There is no crime for having it. There's no unless it's of children. I hope that answered all of the points that you asked for.
Just one follow-up, Mr. Chair. We had, I think it was several years ago, we had the issue of when these issues are investigated, that there was a hard drive that was, or a storage device that was confiscated by the investigators, and they couldn't even duplicate that storage because that would have been a distribution action. And I'm wondering if that falls under the same definition here, that if there's an investigation, if there's an investigation of even a school district, that they can't duplicate what has been stored without breaking the law.
Senator Maye Quade.
Thank you, Mr. Chair. Senator Carlson, in the prohibition on the dissemination of sexual deepfakes, there are many exceptions because it gets into intimate parts. So if it's for, scientific research or treating a patient or investigations or prosecutions, there are exceptions to those things. Yeah.
Thank you. Thank you, Mr. Chair.
Ms. Primo.
Mr. Chair and members, after some conversation, one option could be to, on the A3 amendment, line 1.6, delete, reveal, and insert depict. And I'm wondering if that gets at some of the concerns that were raised.
Senator Maye Quade.
Thank you, Mr. Chair. I think we're getting closer. I do think, just to bring us back to the conversation we were having, I think Monday, that if we're, and to the earlier points, the original unaltered image or video is what's sticking with me, because a lot of this is multiple, it's amalgams of the same person. And so I'm wondering if it could be, is generated to depict an intimate part not depicted by the identifiable individual, or something akin.
Or you could do not depicted in original unaltered images or videos of an identified or identifiable individual. That way you're capturing the multiple nature of the potential sources. You delete the, just say in original unaltered images or videos. And then Ms. Primo actually suggested in a side conversation that the identifiable individual requirement is already contained in paragraph 2, so you wouldn't need to add that to paragraph 1, because there's an and between the two clauses there. Or you could use a belt and suspenders approach and put it in both places, I suppose, either way.
So the site had a folder called My Faces that had a thumbnail of my face, and I went through my Facebook and matched.
Got it. Okay, that's helpful. You don't have to stay here. You can. You don't have to. I told you it's deliberative. Yeah.
I want to jump in with comments, but I don't know what's helpful.
No, yeah, you have to go through the chair. Yeah, that makes sense.
Ms. Primo.
Mr. Chair and members, looking at the A3, the amendment to the A3 would be line 1.6, delete reveal, insert depict. Line 1.7, delete the, insert an. After video, insert of an identifiable individual.
Senator Maye Quade.
Thank you, Mr. Chair. Just wondering, are we missing S's on the end of image and video, or were we?
Ms. Primo.
Mr. Chair and members, one, there are provisions in Chapter 645 that say that the singular includes the plural includes the singular, but additionally, I am not sure if in these situations there would be multiple original unaltered images with identifiable individuals. It seems that if you require a plaintiff to point to all of the images that came together to create the single unaltered image, you might be placing in kind of a high standard and a burden on a plaintiff. I think what the concern is that there is one image taken, like for the example of like a wedding website, where there is one single plaintiff that is identified and that person's picture gets taken and placed on some other images. And I don't think maybe you care about those other original images, you care about that one that belongs to the plaintiff. And so I think that's the only one that you want to have shown, like, hey, this is the one that identifies me, and I did not the parts that were nudified were not in this photograph.
Senator Maye Quade.
Yes, Mr. Chair, yes, absolutely. I agree with Ms. Primo. And I did ask my testifier, Ms. Hurley, how she knew that it was a Facebook photo. And it apparently is because in the folder to create, through the app to create the fake pornography, it was a folder that said like My Faces. And then she went through and matched that face to her own photo. So I agree with Ms. Primo, and that makes sense with the way that the technology is currently set up.
Does this need to be the same person? Yes. So then we do put the here instead of man.
Yes. Yes.
Ms. Primo.
Mr. Chair and members, in addition to the proposed amendment I read earlier, we would also change on line 1.9 of the A3, delete and insert the, with the idea being that it's that same identifiable individual.
Senator Maye Quade.
Thank you, Mr. Chair. Those are great amendments to the amendment.
Any questions or discussion about the proposed amendment? I'll have Ms. Primo reread the amendment for clarity before we take a vote. Ms. Primo.
Mr. Chair and members, looking at the A3, line 1.6, delete, reveal, insert, depict. Line 1.7, delete the, insert an. After video, insert of an identifiable individual. Line 1.9, delete an, insert the.
Senator Maye Quade.
Thank you, Mr. Chair. That is great, and I'm deeply appreciative of the work that we're doing in real time in committee.
Any further discussion? Senator Mover Benton? Just move the amendment.
Thank you, Mr. Chair. I'll move the oral amendment.
All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Mr. Turner, we have some clarification on where 8.31 proceeds go.
Yes, Mr. Chairman and members. Section 16A.72 states that all income to the state, including fees and receipts of any nature, and that would include 8.31 settlements, shall be credited to the general fund. And then it lists a number, it lists 12 exceptions, of which this 8.31 and this would not be an exception. So any settlements under current law would flow to the general fund.
So, Senator Maye Quade.
Thank you, Mr. Chair, and I appreciate that confirmation and commit to working with Senators Kroon and Umer Verbatim to bring in some good language so that this money goes towards supporting victim survivors.
So, if you wish, that would be within the jurisdiction of this committee. Should we, yes, should we choose to act upon
Yeah.
such a suggested change? Am I correct? Huh? Well, let's just see. Whatever you would prefer, Senator Maye Quade. We can certainly leave that issue for between now and Commerce Committee, and you can address it in Commerce Committee, or if you would like, we can address it now. If you'd like to contemplate exactly how you'd like to do it, we have no problem. I think it would be within Commerce's jurisdiction as well, so we wouldn't be punting our own jurisdiction over to them.
Mr. Chair, it's your committee and your time. I am happy to wait while we figure out the language. I'm also happy to do it between now and next committee. I think because it was two members of this committee's idea, I am inclined, I want them to see that go on and know that I very much intend for this to be part of the bill. But whatever you want to do with your committee time is more than fine by me.
Well, we've got the time, Senator Maye Quade. You're the chief author. If it's your desire to change where the proceeds go to that specific place at this time, we can probably figure out the language in the next 15 minutes.
Let's do it, Mr. Chair.
All right. Senator Westland.
Thank you, Mr. Chair. So my question would be, so anything recovered, we're talking about sending to Crime Victim Services, which I 1,000% support. My only question, I think, would be, would the Attorney General's office need to retain any amount of the proceeds to help them be able to bring these suits, is my question, or is that just covered generally by whatever we give them in their budget?
That'd be a state local government thing, too. Yeah, I would think. Did you hear the question?
This is actually, we'll be the first one to do this.
Well, Senator Maye Quade,
Okay, yes, Mr. Chair.
the consensus here is that if we change current statute about where the proceeds of any recovery would go, the bill would then have to go to the Finance Committee in addition to Commerce after this. There is also some discussion about carving out a piece of any proceeds to be reserved for the Attorney General's office to subvent the costs of bringing these causes of action. The conversation also indicated that might have to go to state and local government as well. If you did that, plus there's some concern about whether you want to create a contingent fee type incentive for the Attorney General's office, which I'm not sure would be a great precedent, plus their budget from state and local government is supposed to include the ability to bring all of the 8.31 actions that they could bring, whatever happens to come up at that time. So this just sort of a on-the-record summary of the conversations that have been going on here. If you wish to comment on any of them, love to have your input. But we're working on language if you wish.
Thank you, Mr. Chair. I'm rolling around in my head, like, how many committees do I want this to go to? How many committees want to see my presentation?
The advantage is before you get to the floor, most of the Senate will have already seen it.
Yes, that is also, that's an upside. I would be fine taking this to the Finance Committee. as a member of the State and Local Government Committee, I have no issue with bringing it there. I don't know if, I think I would like to avoid bringing it there if possible, just because the jurisdiction would be so narrow and it's optional. Does the Attorney General typically reserve some of the things in the other parts of the statutes?
I don't think so.
No, then I don't know why we would create something different here. Bless you.
What I was gonna say is that I had this with the MRC last year, the DOC employees, they had a quarter that was the general fund, and they just returned to the victim services, which was already a quarter. They're trying to figure out the operational goals thing right now. And we'll see what it says.
From the fellowship that you and Garrison did, was like the cutest thing I've ever seen in my life. I almost died. I was like, oh, when does he start officially?
He's doing like, he's going to things this week, but then can officially be sworn after the challenge period.
Oh, sure.
Next week, privately, so you can get
Mr. Backus.
Mr. Chair and members, working off the original bill, the amendment would be on line 2.8 after the period, insert, notwithstanding section 16A.72, comma, any civil penalty recovered under this section must be deposited into the general fund and is appropriated to the Commissioner of Public Safety for grants to crime victims services programs, period.
Senator Maye Quade.
Thank you, Mr. Chair. Senator Uma Verbaeten just showed me a bill that she had, and there was some really specific language about what types of crimes. It was victim survivors of sexual violence, sexual assault, child sexual abuse. I'm wondering if we could be slightly more specific just to keep the money with the, with a like.
Yeah, sure. Senator Howe.
Thank you, Mr. Chair. Under that, what's being discussed or what's being proposed so far, does that mean the original victims to get none of this money? Does it, do they get anything out of this? The civil penalties are going one direction. Where do they recover?
So under an Attorney General action, under 8.31, they would get no recovery. But under the other provision, they've got the ability to bring a civil action for damages themselves as an individual, and then they would recover all of whatever they, keep all of whatever they recover under that section.
So does that, Mr. Chair, does that mean that if the AG brings a class action lawsuit in for all those victims, that they still don't recover anything?
Council might have a better answer than I would, but I think under 8.31 actions generally, which basically cover a lot of consumer protection statutes, the recoveries don't go to individual injured consumers anyway. It's not technically in the nature of a class action. It's the Attorney General on behalf of the people of Minnesota. And under current statute, those recoveries all go to the general fund. They don't go to any individuals, except maybe there's some exceptions in that statute that Mr. Turner cited. Senator Limmer.
Thank you, Mr. Chair. Under your answer, does that negate civil action by an individual? I think that's what
Nothing.
Senator Howe is getting at.
Yeah, nothing that we're discussing now would amend the civil action provision that's in this bill.
Right.
So an individual that's injured could still bring their own civil action against the perpetrator, against the website or whatever. Senator Howe.
Thank you, Mr. Chair. My concern is once the AG's office gets done with them, there won't be anything left of the company to actually give anything to the actual victims of the crime. They'll have a judgment, but there won't be anything there for them to get. I guess that's what my concern is the bank account will be dry, the company will be gone, and you'll have a judgment that's not worth the piece of paper it's written on.
They're that small company. Good riddance for that. If they're making money this way. But the larger companies, they would have this, probably would have insurance, perhaps, with the large, I guess you run that risk for in any lawsuit, contact any consumer organization. They could be subject to make one through the case. Senator Maye Quade.
Thank you, Mr. Chair. And Senator Howe, I think it's important to know that almost without exception, all of the apps, platforms, and websites that you use to create this deep fake pornography or sexual imagery, you pay to do it. And it's not, I mean, in order to present this bill, I obviously used Facebook to show you some examples and had a different type of AI photo. And I was going to use Deep Swap AI to see if I could see what it would look like if I nudified myself. But it cost money to do it. It was like $10 or $12. There are some that have a limited, trial subscription, but it's very few functions. So people are paying a lot of money to do this, and so these companies are making a lot of money to make this harmful content.
Senator Kroon.
Thank you, Mr. Chair. I'm a little uncomfortable doing this work on the fly here on this particular part. I'm trying to figure out how this would relate to 8.31 subdivision 2C. And I mean, there it almost, it's talking about funds being recovered to victims. And then here it sounds like we're contemplating an amendment where the funds recovered would go to victims of crime in general and not the specific victims at issue in this particular instance. And I don't know if that's the intent. It really wasn't my intent from the beginning, but, and then also, Mr. Chair, there's another bill out there, apparently, Senate File 447, that is touching on this, and I don't know where that's at, but that's a much larger bill about consumer protection restitution account in general. And I don't know where that's at, but I'm not sure we should be doing this work right now on the fly. I certainly don't fully understand the whole landscape of this.
Senator Maye Quade, what's your preference? You're the chief author of the bill.
Mr. Chair, I think in order to just bring a lot of certainty to what we're going to add, why don't we work on this between here and Commerce and have a fully formed and vetted amendment for that committee, since this also falls under that committee's jurisdiction as well. As long as it doesn't have to come back, that would be great, and we can go from there.
I'm being informed, Senator Maye Quade, that 8.31 is not a Commerce jurisdiction, so we might have to address it here.
Okay. Mr. Chair.
Who said that? Senator Maye Quade.
Two suggestions. One is that we could leave it as is and come back with language after we establish the law. The second is that Senator Uma Verbaten's bill to appropriate specific amount of money could also be amended to pull in money from this bill as well.
A third option would be to lay this on the table here, figure out the language, make any amendments that fall within this committee's jurisdiction at another hearing, and then send it on fully formed from the judiciary's perspective.
Nothing would thrill me more, Mr. Chair.
You're revealing a lot more than you had planned to, Senator Maye Quade.
Or am I depicting?
Depicting is the word.
I chose reveal intentionally there. All right. I think that sounds like the best course of action that can get at the heart of what we're trying to accomplish here. So for today, Senate File 1119 is laid on the table. And members, we will be back in committee on Monday, February 24th at 12:30. Have a great weekend. Thank you. We are adjourned.